The application does not engage this court's exclusive jurisdiction, and no case for direct access has been made out. And it made the following order. 1, direct access is refused. 2, costs are reserved. 3, reasons for this order shall be given at a later stage. These are the reasons. In a unanimous judgment penned by myself, this court finds that the threshold for determination is whether this court has exclusive jurisdiction to entertain the applicant's challenge, and if not, whether direct access should be granted. This required the court to examine what the applicants have pleaded in their founding papers. It is well established that jurisdiction is determined on the basis of the pleadings and not on the substantive merits of the case. What emerges from a careful reading of the founding papers is a case that challenges the lawfulness of specific decision that the President has made. What is notably absent, however, is anything more than a broad allegation that the President has failed to comply with specific constitutional obligations. The founding affidavit is scant and devoid of material evidence to sustain a claim of this court's exclusive jurisdiction. The Constitution distinguishes disputes related to the conduct of the President from those where he has failed to fulfill a constitutional obligation. Section 1674E must be narrowly and restrictively construed. The distinction between exercising constitutional powers and failing to fulfill constitutional obligation is crucial. Section 1674E addresses only the latter category. While when the President exercises a power, even if that exercise is challenged as improper, the inquiry concerns a positive act rather than an omission or failure. President-specific constitutional obligations are readily identifiable by their mandatory character. Provisions that provide that the President must act in specified circumstances. A failure to perform any of these mandatory President-specific obligation would engage this court's exclusive jurisdiction. However, sections like Section 84(2) and other provisions confer discretionary powers on the President using permissible language that indicates that the President may exercise those powers. The applicant's complaint in this case, it's not that the President failed to exercise his powers, but rather that he exercised them irrationally or ultra vires, in other words, beyond his powers. Such complaints concern the matter or the manner of exercising constitutional powers and not the failure to fulfill constitutional obligations, and fall within the standard review jurisdiction of the High Court. The applicant's reliance on Section 83B of the Constitution is therefore insufficient on its own to ground this court's exclusive jurisdiction. Applying the principle established in EFF 1, this court finds that Section 83B must be coupled with a specific constitutional obligation in respect of which there has been a failure. No such agent-specific obligation is identified in this case. The broad approach taken by the applicants to the issue of exclusive jurisdiction without sufficient averments in the pleadings to make out a case is legally untenable. The applicant's complaint is the manner in which the President has dealt with the revelations made by Lieutenant General Mkp'S. Thus, none of the impugned decisions constitute a failure by the President to fulfill his constitutional obligations. Having determined that this court exclusive jurisdiction is not engaged, this court proceeded to consider the alternative ground of direct access under Section 167(6)(a) of the Constitution. It is tried that this court grants direct access only in exceptional circumstances and if it is in the interest of justice to grant it. Applying established principle, this court finds that several considerations militate against granting direct access in this matter. First, the novelty and the importance of the issues raised favor initial consideration by the High Court. Second, there is no agency that necessitates this court sitting as a court of first and last instance. Third, although a High Court declaration that the President has acted unconstitutionally would require confirmation by this court to be effective, Section 167, subsection 2b of the Constitution empowers the High Court to grant interim relief pending confirmation. The applicants have not adequately explained why they did not pursue this available avenue. The fact that appellate or confirmation proceedings might follow a High Court's judgment cannot undermine what the Constitution says about the proper allocation of jurisdiction. The importance of issues in a case do not without more constitute exceptional circumstances and justify this court being a court of first and last instance. The more important and complex the issue in a case, the more compelling the need for this court to be assisted by the views of another court. In the result, the application cannot succeed on either threshold. This is not a matter that falls within this court's exclusive jurisdiction under Section 1674(e) of the Constitution, nor is it one where the interests of justice favor direct access under Section 167(6)(a) of the Constitution. Accordingly, it is not competent for this court to opine on the merits of the applicant's challenge to the impugned decisions, and that issue must be left for the right time and at the appropriate forum should the applicants be so inclined. On the question of cost, I find that although the applicant's case for exclusive jurisdiction and direct access is unsuccessful, the constitutional questions they sought to raise were not entirely without merit. The jurisdictional claims, though sufficiently pleaded, are not so manifestly hopeless as to warrant costs. By-and-large protection is that warranted in the circumstances, and each party should bear their own cost. I hand down the judgment.
As the court pleases.
Oh,
As the court pleases.